My lord, we all know, my lord, about the background of this case, my lord. How, my lord, owing to intervention of the Honorable Court,
1 minute.
Mammoth,
1 minute. The state is there. I cannot see you. You are behind the screen. You were directed to take instructions with regard to the steps taken pursuant to the GD. Let me see. Your report mentions that the computers were checked and 60 number of unknown Excel files in one of the computers, and the traces of downloading them were not seized by the team of the Enforcement Directorate. So they were not seized.
That computer, that hard disk was
Not seized. So it implies that they do not intend to take any note of those documents which were downloaded, isn't it?
not that. They intended, like,
Well,
oh,
had they intended to use them, they would have certainly seized.
but we have, in course of this inquiry, we have seized them, and we have sent it here.
But as of now, there is nothing to suggest that those documents which were downloaded has been used by the authorities against you or for the purpose of investigation.
Again, us means, not about us, as the
Means
signatory of
the-
report,
Yes.
nothing to do with them, but however, we have given them email to send a representative. They have said that there is no difficulty. We have difficulty in sending a representative, but whatever query you have, you can give it by mail. And I understand, another criminal revision is pending before a coordinate bench. But however, though I am not an appearing counsel there from the state, but from my counterparts there, what I learned is that this issue was brought up in that criminal revision, and it was verbally it was discussed in court that there is no harm in sending the email. However, I can ask my counterparts to come and make the submission.
No, that is all right. But the fact
I
that
can assist my lord as far as that is concerned, my lord, because in that regard only we have today, with my lord's leave, I have filed an application. It has been numbered as computer application number 8 of 2023. Now, my lord, there we have specifically mentioned, my lord, that this particular issue has been put to rest by the order of the Honorable Coordinate Bench of this Honorable Court, where Mr. Abhishek Banerjee had filed a criminal revision with regard to something else. He took out an application, the interlocutory application saying that this has happened. There is an undertaking given by ED that first of all, we have not seized it. And we are not going to use it as evidence because we have said that those are not such files that we wanted to do anything, or it has nothing to do with it.
with the investigation.
Yes, my lord.
So what is the use of continuing with the same
my lord will
and
think that-
harassing all these officers by giving regular mails, come, give this, that, why?
Mails means, we have sent 2 to 3 emails only. The first one was seeking an answer, which they have given, that answer, also I can please.
No, but then after the authorities have submitted before the court that they are not going to use those documents, if at all, for investigation purpose, what remains right now? Right now.
This complaint which is there before us, we are only taking it forward in terms of the complaint. So it is not between the investigating, the person investigating here.
Very well, I have followed
and
it.
that of the
Yes, I've got it. Anything else you want to submit?
my lord, I am for the CBI, my lord.
Yes.
In our application, my lord, we have challenged, my lord, the action undertaken by the special court, my lord. My lord, completely, my lord, ignoring, my lord, the law of the land, the hierarchy of courts.
Isn't your application pending before the Supreme Court challenging the action of the?
Court has granted us liberty. We had filed a clarification application.
Yes.
I'll tell you, lordship, what
That
happened.
is what appears from your earlier report.
Yes, my lord, I have revealed everything in my application, my lord, what has
All
happened,
right.
my lord. My lord, kindly comes to the Supreme Court order once, my lord. It all started from the Supreme Court order at page 76. If your ladyship kindly takes pain to come to page 76 once.
Yes.
My lord, may kindly take note of the fact, my lord, the SLP was arising out of, my lord, the judgment and order dated 18/5/2023. My lord, may kindly mark, my lord, 18/5/2023. I just place the order dated 4th of August 2023. The grievance which has been addressed before this court by Mr. Such and Such senior counsel appearing for the petitioner is that It was not the petitioner who had moved the High Court, but it was the Enforcement Directorate who had done so. Moreover, it has been submitted that the complaint of the petitioner in regard to the allegation of custodial torture would have to be looked into by the competent court. In this background, it has been submitted that the observations on merit by the High Court were unwarranted, as also direction to deposit costs of 25 lakhs. We have heard Mr. S.B. Raju, Additional Solicitor General. Now, thereafter the finding, the High Court has clarified that at that stage, it was not expressing any opinion on the legality or correctness of the complaint in regard to custodial torture. In the circumstances, the impugned order, my lord, may kindly mark, my lord, the impugned order of the High Court shall not preclude the petitioner from pursuing the complaint before the special court. The order for payment of cost of rupees 25 lakhs shall stand deleted. Now, thereafter, my lord, may kindly, my lord, I'll be referring to your lordship's order, my lord, which was in effect, my lord, affirmed, my lord, in this SLP, because only the cost portion was deleted. And this particular, the impugned order, that is the order dated 18th of May, 2023, that would not have been a bar, my lord, from pursuing it, my lord, before the special court. This was the observation. It was not spelled out, my lord, as to, my lord, whether it is to be the CBI court or the PMLA court, because the CBI and ED are both investigating, my lord, in this matter. Now, if my lord kindly takes your ladyship's order, my lord, which starts at page, of the order, 18 by page 46. Now, my lord kindly takes page 66 of the petition, internal page 21 of the order, dated, my lord, 18th of May, 2023. Now, the second paragraph, all applications as indicated in the order of the Honorable Supreme Court has to be necessarily interpreted as applications on issues not decided by the court. The same cannot be read as application with issues already adjudicated and decided by the court. If the formal interpretation is to be accepted, then there will be no end to a dispute and there will be a possibility of the losing party approaching the court to re-argue and re-agitate the issue all over again. Finality of an issue can never be reached. The same is contrary to the principles of res judicata. Now, my lord, on the strength of these observations of your ladyship, my lord, which was not, my lord, even, my lord, interfered with by the Honorable Supreme Court, my lord, these applications, my lord, are taken out at the behest of the CBI and the ED, my lord, because these are all subsequent facts, my lord. And my lord, the law is very clear, my lord. Popular Muthaiya has said, my lord, that the Honorable High Court, while exercising powers, my lord, the powers are plenary in nature, and it can do anything ex debito justice, my lord, to correct the course of justice. Where, my lord, it is basically an abuse of process. And there was another case also, my lord, that Rajesh Prasad, yes, 2014 SCC. I'll be referring to all of them. Supreme Court cases, page 257, which spells out that the court monitoring the investigation has to act as a guardian to ensure that the officers who are conducting the investigation are not exposed to unnecessary harassment from the persons at the top of the ivory tower wielding power. So these are there. So thereafter, my lord, I'll urge your lordship to kindly take a paragraph, my lord, thereafter, my lord, the paragraph that I placed, my lord, the last but one paragraph. The conduct of the applicants in resisting investigation casts a cloud on the bona fide of the applicants in filing the present application. AB, being in the top rung of the ruling political party, ought not to shy away from the investigation process. On the contrary, the applicants, and particularly AB, is trying tooth and nail to oppose such investigation. The proper approach would be to put oneself to test and come out clean instead of avoiding or running away from the entire process. Now, thereafter, this is very relevant, my lord. The state machinery, especially the police, also appeared to back the accused. The hyperactivism of the Superintendent of Presidency Correctional Home is also worth noting. The lightning speed in which the Superintendent acted on receipt of the complaint of Kuntal Ghosh is clear proof of his faithfulness to the state. Now, Kuntal Ghosh is already in jail custody and will be dealt with appropriately in accordance with law. At this stage, it does not appear that any of the rights of the applicants have been infringed in any manner requiring interference by the court, either by the act of the respondents or the order passed by the court. Now, thereafter comes, my lord, the observation of the Supreme Court, my lord, in the order that I just pointed out. Learned counsel representing ED, while referring to the complaint lodged by Kuntal Ghosh, has specifically pointed out that the complaint in question is neither in proper form nor in accordance with the provision of the jail code. The superintendent of the correctional home was extra vigilant and forwarded the complaint to the officer in charge Hastings Police Station with utmost promptness. At this stage, the court is not expressing any opinion with regard to the legality or correctness of the state complaint. The same will be taken on note at a subsequent stage if occasion so arises. Now, my lord, I'll just pause here for a moment, my lord. Now, this particular order, my lord, of 18th of May was under challenge. Subsequently, my lord, these matters were taken up by your ladyship, my lord, on 14/6/2023, 14/7/2023, and various dates thereafter. When, my lord, upon pursuant to directions by the Honorable Court, my lord, the CBI had filed a report insofar as, my lord, these particular allegations were concerned, pursuant to, my lord, directions of the Honorable Court. But that report were taken into consideration. My lord's order has also been annexed, my lord, the order dated 14/7/2023, where it has been specifically recorded about filing of the report and what is the conclusion in the report. Now, but thereafter, but I'll also refer to two more paragraphs, my lord, and I'll go to the order impugned of the special court. But the last but one paragraph at page 67. After the first sentence, the applicants have indeed been successful in interrupting the investigation to a great extent. It is high time that the investigation process be brought back to the right track and proceeded in the right earnest so that the same reaches its logical conclusion at the earliest. If the trend to delay the main investigation and intimidate the investigating officers is not dealt with appropriately at the very first stage, then the same will develop as a style, and very many investigations in future may be held up for same reasons. Such a move must be stopped with an iron hand and upon imposition of exemplary costs, so that the same has a deterring effect and similar offenders will be compelled to think multiple times before adopting such a stand. In view of the discussions made thereunder, the applications were dismissed and a cost to the tune of rupees 50 lakhs was imposed, which was interfered with by the Honorable Supreme Court, and nothing else. And with this with this observation that he will not be, by virtue of the impugned order, the petitioner will not be debarred from pursuing the complaint before the special court. Now, after passing of this order, may I mention, also, that the original complaint made by Kuntal Ghosh, that is, with the records of the Honorable Court, with your ladyship, because those were, asked to be produced and the originals are there. Now, what happened thereafter? If kindly take page 78, this is where from it all started. The CBI court number 1, which is a charge court, But suddenly, on 21st of August, an application was filed by this under trial prisoner. But no application has been served upon the CBI till date. The CBI appeared and apprised the learned special judge about the fact that there are subsequent developments. A report has been filed and taken note of by her ladyship in the court-monitored investigation, which was deliberately not recorded. I am using the word consciously, deliberately not recorded. Thereafter, what happened was, the special judge suddenly said that I will call this Kuntal Ghosh, the under trial, to my chamber. I do not know what prompted him to call an under trial to the chamber. It was not an in-camera proceedings. Nothing has been spelled out for calling, of the under trial prisoner in the chamber. And thereafter, your ladyship kindly takes note of what has happened. I'll place the order. Accused Niladri Ghosh, Kuntal Ghosh and Taposh Mondol are produced before this court. Honorable Apex Court has been pleased to direct, in the circumstances, the impugned order of the High Court shall not preclude the petitioner from pursuing the complaint before the special court. Honorable Register has been pleased to direct this court to comply with the direction. And as such, I have asked the accused, complainant herein, to come forward, and accordingly he is now in front of me. The original complaint lodged by Mr. Ghosh is lying with the Honorable Court. Kindly mark this. I have asked the person, that is Mr. Kuntal Ghosh, whether he will submit before me in presence of the learned advocates and other persons, or in my chamber. And the complainant, due to some averments made in his application filed earlier, wants to submit at my chamber, and accordingly I am directing IO to produce the complainant at my chamber. Kindly mark this, my lord. The special judge, my lord, volunteers that, will you like to tell anything here or in my chamber? It was not, my lord, at the behest of the under trial, my lord. Now, thereafter, what happens inside the chamber? Letter, order number 36. Kuntal Ghosh is produced before me at my chamber. There are two complaints. My lord, the records, my lord, what was handed over to us, my lord, by virtue of orders passed by the Honorable Court, my lord. I'm grateful to Mr. Bandyopadhyay, he had circulated copies. But there is only one complaint which was made, my lord, to the special judge. I do not know what other complaint he is referring to. The special judge was only, my lord, addressed with a complaint dated 31st of March 2023. But here he speaks about two complaints and in his chamber. One against Vijay Kumar, Assistant Director ED, and one Ramdin Dagar, Deputy Director, and one DIG of CBI. On asking Mr. Ghosh, he ultimately has told his name as Ashwin Shenvi. I fail to understand, my lord. A complaint is not there in its original. The complaint is lying with the Honorable High Court at Calcutta. In the complaint, there is nothing mentioned. It was said, the allegation was, my lord, as wild as one DIG did this and did that. So the judge, it seems, my lord, in the learned judge in the court below, literally, my lord, persuaded the under trial, and after such persuasion, but the name was spelled out as Ashwin Shenvi, because, my lord, this word ultimately, my lord, gives such feeling, my lord, that there was a lot of persuasion. Then you tell me, but this is nothing but a roving inquiry, a fishing. This is nothing but, my lord, fishing out of evidence. I'll refer to the provisions of, my lord, the Code of Criminal Procedure also. He is not even authorized, my lord, to take cognizance. And, my lord, what the Honorable Supreme Court directed was, my lord, to pursue the complaint, not to adjudicate. Now, my lord, kindly appreciates, my lord, what has been done, my lord, despite a court-monitored investigation being ongoing, my lord. The first offence was happened as per the complainant was at his residence lying and situated at Ujjwala Luxury Complex opposite City Center and tower number such and such. And another happened at ED office at CGO complex, and another happened at CBI office Nizam Palace. The complainant categorically stated that he has no allegation against the prosecution agencies, but he has grievances against the particular persons considered. My lord, Mr. Shenvi, the DIG, has been appointed, my lord, as the head of the SIT by virtue of orders passed by the Honorable Court, my lord. Upon appointment of Mr. Shenvi, my lord, he happens to be one of the most competent officers, my lord, of the CBI. He has come from Chandigarh, my lord, to head the SIT pursuant to court orders. And, my lord, he has even, my lord, appeared before the Honorable Supreme Court, my lord, in SLP, connected with this scam, my lord, to apprise the court about the progress of the investigation, my lord. And after, my lord, Mr. Shenvi taking over as the head, my lord, there has been much progress, my lord, which we have indicated by filing reports, my lord, time and again, my lord, about, my lord, my lord, the acceleration, my lord, insofar as the speed of investigation in this mammoth scam is concerned, my lord. Now, thereafter, my lord, again, later order number 37. It is true that there are two parts of the allegation. The accused complainant herein wants to leave my chamber, and accordingly, I have asked the IO to take Mr. Ghosh at my ejlash. And thereafter, order number 37. It is true that there are two parts of the allegations. One is against two officers of ED and another against one officer of CBI. As Honorable Apex Court has been pleased to direct this court to adjudicate the matter, my lord, kindly marks this, my lord. It was not the Honorable Supreme Court which said, my lord, that he has to adjudicate it. The Supreme Court spoke about pursuing it in light of the impugned order, my lord, that is the 18th May order. I am inclined to take both the applications of the complainant accused herein for passing order. My lord, I do not know, my lord, the originals are with your ladyship's record, my lord. But I have made a photocopy of, my lord, what was handed over to me by Mr. Bandyopadhyay, my lord. By the court, pursuant to Mr. Bandyopadhyay, pursuant to court's orders. Right? Oh, he has given it to the court, and thereafter the court had, yes, court had circulated copies. Yes. But I have made this compilation. If my lord kindly takes the complaint, my lord kindly takes page 9. I'm sorry, my lord, page 7. Now, this contains the certificate under section 65B of the Evidence Act, of the officer in charge of Hastings Police Station. Thereafter, page 8 is, my lord, the email. Page 9, the Presidency Correctional Home forwarding, my lord, the prisoner's petition. And page 10 is, my lord, the complaint addressed to the inspector in charge of Hastings. And thereafter, if your ladyship kindly takes pain to come to page yes, page 15. Now, my lord, this is, my lord, the only complaint which was addressed to, my lord, the special court. There are no two complaints, my lord. The complaint is thereafter, my lord. It runs from page 16 to page 20. This was a continuation. Two parts were made, ED and CBI. So there was this one complaint only. In any event, my lord, coming back to the order, my lord, I'll run through the, my lord, contents of the complaint again. As the accused has filed both the complaints before this court and the original complaints are lying before the honorable court, at the time of adjudicating such type of matter, the matter should be dealt with in such a manner so that fairness of the judiciary should be highlighted. So no copy served upon the CBI, submissions not recorded, but, my lord, this is highlighting, my lord, the fairness of the judiciary. The accused has fairly submitted that he has no grievances against the prosecution agency in one hand, and on the other hand, it is the duty of the court to look into the matter in such a way so that neither of the party can claim of causing prejudice to him. Considering all, I am of the opinion that if one report be called for from the Joint Director CBI and Joint CP Crime Detective Department Lal Bazar under the supervision of any learned magistrate, then question of causing prejudice to, it two has been missed out, to any person cannot and does not arise at all. So, my lord, Justice Amrita Sinha's order, the observations made therein which were not, my lord, interfered with by the Honorable Supreme Court on 18/5/2023, my lord, the observations regarding the role of the state, the hyperactiveness of the role of the police, my lord, these were all brushed aside. As if, my lord, it is only the Supreme Court and, my lord, the special judge, the subordinate court, my lord. There is no existence of any high court. I'll show, my lord, what he is doing. Both the concerned officers are strictly directed to hear the grievances of Mr. Kuntal Ghosh, his wife Joyshri Ghosh, and will record their statement and record statement of any other person as may deem fit and proper. They shall record the statement of Kuntal Ghosh first, and then they are at liberty to hear the submissions of the persons against whom Mr. Ghosh has placed his grievance, and then they are at liberty to collect any other evidence jointly as they may think fit and proper, and ultimately Mr. Ghosh and the officials against whom Mr. Ghosh has placed his grievances will be examined in the presence of learned magistrate at his chamber or at any place as directed by learned magistrate, and in this matter learned magistrate will be treated as a representative of this court. Who is he? I mean, he's not a constitutional court. He has very, very limited powers which are regulated by the CRPC and by the criminal rules and orders. He's acting in an extra constitutional manner. He cannot direct the course of any inquiry. He cannot direct any officer beyond the rank of an officer in charge, an inspector of police, my lord, to take part. And, my lord, the facts, my lord, regarding, my lord, the orders being passed by the Honorable Justice Abhishek Banerjee on 13/4/2023, which was the merits of which were not interfered with by the Supreme Court, my lord. Only, my lord, there was a request made to the Honorable Chief Justice of Calcutta High Court to reassign the matter to any other bench, my lord. That was completely ignored. My lord's orders, the subsequent orders passed by your ladyship, my lord, those were totally brushed aside. Learned Chief Judicial Magistrate Alipur, being the head of criminal administration, is directed to depute one magistrate in this regard, and the concerned officers are directed to inform the learned magistrate well in advance as regards the date of examination as required as per the observations made herein above. The concerned officers are also at liberty to inquire into the matter by any other mode as they may think fit and proper, and should submit a report in this regard before this court jointly and or separately by 21/9. Thereafter, my lord, kindly takes, my lord, the last 3-4 lines. The application filed by Kuntal Ghosh, inter alia praying for sending the matter before the concerned police station, is dispensed with till arrival of the report. So Justice Abhijit Gangobadhyay's order dated 13/4/2023 23, which insulates the officers of the special investigation team against registration of any FIR or taking cognizance without the leave of the court, that is also completely, my lord, ignored. Because, my lord, he seems to have assumed a very, very special jurisdiction which finds no place in the Constitution of India, my lord. He seems to function, my lord, even not only a court of record, my lord, but a super court of record, having all the powers, my lord, which are also vested in the Honorable Supreme Court of India under Article 142 of the Constitution of India, and also, my lord, to the Honorable Constitutional Court, my lord, to, my lord, do justice, my lord, ex debito justice. Now, thereafter, my lord, the next order, the order dated 1/9/2023, received the letter of learned Chief Judicial Magistrate and also learned Judicial Magistrate, 3rd Court, Alipur, and Joint CP Crime. The intention of the court is not to submit conflicting decision or report, and he is doing that. The intention of the court is to obtain one joint report from Joint Director of CBI and Joint Commissioner of Police, D.D. Lalbazar. The overlapping attitude is not expected at all, expected. Joint cooperation is highly solicited. Both the officers will fix date jointly and to do following acts. So thereafter, my lord, I have, my lord, there must be some typographical error. It doesn't make much sense what has been, my lord, intended to be recorded. Now thereafter, my lord, the last two lines. It is to be mentioned that if there will be any non-cooperation, then the matter will be forwarded before the Honorable Apex Court to date. A special judge. I was amazed. I was embarrassed. A charge court doing these things. So we file an application thereafter that please keep it in abeyance. We have gone before the Honorable Supreme Court of India seeking a clarification because there are subsequent orders, etc., etc. So that order, my lord, will find in page 83. So record is placed before me on the basis of application filed by Superintendent of Police, CBI, SIT. Peruse the application, documents annexed, copy served. Thereafter, learned advocate of Kuntal Ghosh has brought my attention in paragraph number 3 of application, and in this regard, I am of the opinion that rather than it can be said that Honorable Court has been pleased to direct this court to send the letter submitted by Kuntal Ghosh in original and as per the direction of the Honorable Court in WBS 7907 of 2019, this court has placed the before the Honorable, this is Hebrew and Latin, but before the Honorable Bench directly, and the receipt of ACO of courtroom number 17 is here. And as such, question of seizing the matter by the Honorable Court cannot and does not arise at all. But the fact remains that the original letters are lying with the Honorable Court, and the Xerox copies, including the receipt copy of the Honorable Court, is lying with the case record. And the same I have already been mentioned in my order dated 21/8/2023. So thereafter, my lord, our prayer was considered. He said that no, you either get an order from the Honorable Supreme Court, otherwise I cannot keep any order in abeyance. So thereafter, my lord, we moved the Honorable Supreme Court of India. The Honorable Supreme Court of India on 6th of September was finally said that, see, there are various other orders. We will not go into the merits of a finally disposed of SLP. So we are not entertaining the miscellaneous application. But however, we are granting liberty to the CBI, to the applicants to pursue the remedies in accordance with law. So on this, in light of, my lord, this particular, my lord, observation, the liberty granted, my lord, I mentioned the matter before your lordship, pursuant to which, my lord, leave was given by your ladyship. Now, my lord, the first aspect is, my lord, a magistrate in a subordinate judge, my lord, is regulated, his functioning is regulated, my lord, by the Code of Criminal Procedure.
First, address as to whether this court has jurisdiction to look into these judicial orders passed by the learned
Yes,
court.
yes, my lord has. My lord has.
Because there is a separate jurisdiction,
No,
the criminal
my lord
division
has.
jurisdiction can be availed of.
Very well. I'll tell your lordship why I am before your lordship, my lord. Now, there is this judgment of Popular Muthaiya, which is again a very popular judgment. Para 30 of Popular Muthaiya says that my lord, the Honorable High Court, while exercising incidental powers or supplementary powers, hearing applications, it can always exercise inherent jurisdiction. And it can do anything, my lord, in exercise of powers, my lord, the constitutional courts, my lord, to correct any wrong ex debito justice, my lord. So I'll just be referring to, my lord, Paragraph 30 of Popular Mutaya. I'll just place para 30. In respect of the incidental or supplemental power, I'm sorry. Yes, I'm very sorry. 2006-7 Supreme Court cases, page 296. Yes. In respect of the incidental or supplemental power, evidently the High Court can exercise its inherent jurisdiction, irrespective of the nature of proceedings. It is not trammeled by procedural restrictions in that power can be exercised suo motu in the interest of justice. If such a power is not considered, it may even lead to injustice to an accused. Such a power can be exercised concurrently with the appellate or revisional jurisdiction, and no formal application is required to be filed. It is, however, beyond any doubt that the power under section 482 of the Code of Criminal Procedure is not unlimited. It can inter alia be exercised where the court is silent, where the power of the court is not treated as exhaustive, or there is a specific provision in the code, or the statute does not fall within the purview of the court because it involves application of a special law. It acts ex debito justice. It can thus do real and substantial justice for which alone it exists. Now, my lord, I'll garnish this with another judgment which speaks about, my lord, the responsibilities of an honorable court, my lord, in a court-monitored investigation, my lord. That is reported in 2014, volume 14, Supreme Court cases, page 257. My lord, we have power, my lord. The high courts are courts of records, my lord, under Article 215, my lord, as the Supreme Court is, my lord. So, 2014 SCC, page 257. But the paragraphs which will be relevant are para 7 and para 27. Here, my lord, it was in case of a court-monitored investigation, there was hindrances were attempted to be created. So what he did was, my lord, they directly approached the Supreme Court, my lord, under Articles 129 and 142. And this is what the Supreme Court holds. We are in this case concerned with the question as to whether, para 7, my lord, there has been any attempt on part of the respondents to interfere with an investigation which is being monitored by this court. When a court monitors a criminal investigation, it is the responsibility and duty of the court to see that the investigation is being carried out in the right direction, and the officers who are entrusted with the task be not intimidated or pressurized by any person, however high he may be. Considerable responsibility and duty is cast on the court when it monitors a criminal investigation. People have trust and confidence when the court monitors a criminal investigation, and the court has to live up to that trust and confidence, and any interference from any quarter to scuttle that investigation has to be sternly dealt with. Exactly these words were spelled out by your ladyship also in those paragraphs of the order dated 18/5/2023, which are very much subsisting, my lord, and which have, I will say, my lord, which have been affirmed by the Honorable Supreme Court. Thereafter, my lord, para 27. We may indicate that the petitioner has inter alia invoked the jurisdiction and power conferred on this court under the above mentioned constitutional provisions, and hence the consent of the Attorney General is not necessary. The petitioner is only expected to bring to the notice of this court the problems he confronts with while carrying on a court-monitored investigation, and it is the duty and obligation of the court to see, rather than the petitioner, that nobody puts any pressure or threat on an officer entrusted with the duty to investigate a court-monitored criminal investigation. Any interference by anybody to scuttle a court-monitored investigation would amount to interfering with the administration of justice. The courts, if they are to serve the cause of justice, must have the power to secure obedience to its orders, to prevent interference with the proceedings, and to protect the reputation of the legal system, its components, and its personnel who on its behest carry on a court-monitored investigation. The court is duty-bound to protect the dignity and authority of this court at any cost, or else the entire administration of justice will crumble and law and order will be a casualty. Well, this is one of the second principle, my lord, where I am highlighting, and I am, my lord, also relying on my lord's observations in the order dated 18th of May 2023, my lord. where my lord had exactly anticipated what was happening. And now, my lord, the anticipation has merged with actual reality. To see, my lord, today I am coming up with an application as to what is happening. My learned friend, my lord, my counterpart, Mr. Trivedi, he is coming up with another application, my lord, demonstrating, my lord, what is being done with, my lord, the officers investigating, my lord, insofar as the ED is concerned. So it is continuing, my lord. Now, my lord, I am more on, my lord, the question of absurdity, my lord. My lord, what is, my lord, the most surprising and striking feature is, my lord, there are two complaints, my lord. One was made to the police by this under trial prisoner Kuntal Ghosh. The other one was made, my lord, to the jurisdictional judge, to the special judge. The special judge's complaint was dated 31/3/2023. The police a day after 1/4/2023. Both are there, my lord, what I have handed over. Now, my lord, there has been an improvement, my lord will find. The 1st April complaint has been improved from what was written in the 31st March, my lord, complaint. Now, my lord, the alleged period of torture insofar as, my lord, the CBI is concerned, but that dates from 20th of February 2023 to 24th of February 2023. Between these periods, he was produced, my lord, before the magistrate on 23rd of February, 9th of March, 23rd of March. I have the orders, my lord. The compilation contains the orders, my lord. The orders will be of much relevance because not only was he produced, the medical examination was done, SSKM doctors were there. Am I there, computer? Order? Huh. And he also moved bail applications, but nothing was spelled out. Till, my lord, these complaints, my lord, were on the 31st of March. So, once the complaint was placed before this particular special judge only, who has now, my lord, for showing, my lord, that impartial judicial my lord, functionality, my lord, has called this under trial prisoner to his chamber, volunteered, my lord, to ultimately disclose the name of something, my lord, which was not there, my lord. A complaint which is, my lord, inherently vague, my lord, and absurd, was attempted to be, my lord, even improved, my lord, by, my lord, possibly persuading, my lord. This is persuasion only because ultimately the name was disclosed as Ashwin Shenvi, my lord. Now, my lord, the কোনটা দেখাচ্ছিলাম ভুলে গেছি orders গুলো, yes. Now, my lord, kindly takes, my lord, the orders, my lord. It starts from page 1, 23rd February. This is after the alleged period of torture. 20th of February to 24th of February, he is being tortured. He's writing to the jurisdictional, to the CBI judge that my private parts were under attack, and one DIG was telling me that, tell me how much money you have received from Abhishek Banerjee. Again, a day after that, on 1st of April, April Fool's Day, he's writing to the police telling that my private parts were under attack, and the DIG was forcing me to tell me whether if you have whether Abhishek Banerjee has taken any money from you or not. So there is a clear distinction, my lord, to establish, my lord, the absurdity. Now, my lord, the order dated 8th of order number 8, my lord, dated 23rd of February 2023. So Kuntal Ghosh, Niladri Ghosh, Taposh Mondol, they were all produced from PC. IO had prayed for JC in respect of accused persons such and such. Learned advocate for the accused persons move for bail on the ground stated in their respective application, and in particular, learned advocate of Taposh Mondol also moved for bail on the ground of his serious ailment. On hearing of both sides and on perusal of case diary, I can say that Mark Twain, my lord, the great American philosopher and writer, has been pleased to describe the chain of evidence as take a word, split it up into letters. The letters may individually mean nothing. When they are combined, they will form a word with meaning. I don't know what he said. Learned advocate for the accused person submitted that the basic ingredients of section 7 and 7A of PC has not been established. Thereafter, my lord, the order runs to record. Medical report. So, my lord, he moves, my lord, a bail application, my lord, on the 23rd of February. My lord, the next order, 9th of March. Again, my lord, they are this. Oh, my lord is looking at the compilation, my lord.
No, I'm looking at your application.
Oh, application, yes.
Where are you reading from?
My lord, the compilation that I handed over containing the, my lord, the complaints, my lord, that contains the 3 orders also, my lord. Where, my lord, which demonstrates that this Kuntal Ghosh He was produced thrice before the magistrate. My lord, during this particular interregnum, 20th to 24th, there was torture inflicted according to him, which he informed my lord finally on the 31st of March. So, my lord, between that period, my lord, he was produced, nothing was spelled out. He was, my lord, he has moved moved applications for bail. He has got, my lord, even, my lord, medically examined. Nothing was spelled out till, my lord, this came. So the second order, my lord, 9/3/2023. Again, my lord, Kuntal was produced. My lord, 1, 2, 3. The fourth paragraph, application filed on behalf of accused Kuntal Ghosh and Taposh Mondol taken up for hearing. So he moves an application. Thereafter, my lord, CD Perus, thereafter, my lord, Perus, the report of the superintendent of Presidency Correctional Home along with report of senior medical officer. It appears that the medical board had been formed by SSKM Hospital and diet chart of SSKM Hospital is being followed. So everything was done. Nothing was spelled out. Thereafter, again, my lord, on 23rd of March, again he was produced. So Kuntal Ghosh, along with two others are produced. He once again moves another application, my lord, the fourth paragraph. Now the application filed on behalf of Kuntal Ghosh and Niladri Ghosh is taken up for hearing. So he moves for bail. The learned advocate for the accused person submitted that these persons are neither any government employee nor any person who has benefited by way of receiving appointment letter. Thereafter, again, my lord, the last but one paragraph, peruse the report of the superintendent of Presidency Correctional Home along with report of senior medical officer. It appears that the medical board has been formed by SSKM Hospital and diet chart of SSKM Hospital is following. So these are the observations. And my lord, the initial reaction of this particular judge only when the complaint was received. My lord will find it at the it's appended to the petition, page 28. This is the order dated 6th of April 2023.
Tell me one thing.
My lord.
What could the learned judge would have done? Because there is the court's order of the Supreme Court.
My lord, the Supreme Court had granted liberty to pursue it before the special court without spelling out.
What is to be done and how it is to be
No, I'll
done?
tell you, Lordship, my lord, I'm coming to that. It was only with regard to, my lord, the order dated 18th of May.
Yes.
The learned special court was apprised about the subsequent developments. Orders were shown on behalf of the CBI. That was consciously not recorded. My lord. We prayed, we pleaded, my lord, for a copy of the petition filed by Kuntal Ghosh. That was not there. First and foremost, my lord, under the CRPC, my lord, in the absence of a complaint, my lord, there cannot be any adjudication. There cannot.
One complaint was there.
No. Complaints are all with the records of the Honorable High Court. He was not having any complaint. He is recording that. Despite that, he is proceeding in hot haste.
Original is not there, but the photocopy must have been there.
Without calling for the original, my lord, there cannot be, my lord, the courts which are confined within the four corners of the CRPC, my lord, which function, my lord, in accordance with the CRPC. They cannot go beyond that, my lord. They do not have, my lord, the plenary powers, my lord, which are, my lord, available, my lord, to the Honorable High Court and the Supreme Court, my lord.
So in the absence of the original complaint,
my lord, kindly takes the CRPC once, my lord, but kindly take section 190, subsection 1, my lord. That speaks about complaint, my lord, adjudication on complaint. 190, subsection 1, subsection A. And that is what the Honorable Supreme Court also says. The role. Mind has to be applied. And that has to be done, my lord, specifically by a magistrate, not him. No.
so your submission is that in the absence of the original complaint,
My submission is, my lord.
it could not have been.
No. My submission, I will be referring to another judgment, my lord. So 190, cognizance of offences by magistrates. Subject to the provisions of this subchapter, any magistrate of the first class and any magistrate of the second class specifically empowered in this behalf under subsection 2 may take cognizance of any offence. Then A is upon receiving a complaint of facts which constitute such offence. So this is exactly what was there, but the complaint was not there. He should have ideally waited for further orders. He should have recorded that there are further orders passed by the Honorable High Court. There are subsequent development because the Honorable Supreme Court had made it subject only to the impugned order, my lord. The impugned order will not preclude because the High Court at that stage has not expressed any opinion. But thereafter on 16th of June and 14th of June and 14th of July, the reports were submitted, but the interim report was initially submitted. The final report was submitted. And it was contained, it was pleaded, but it was stated there in manner that this is inherently absurd, but the opinion of the medical board, of the doctor seeing him, everything was collected. Everything is before your ladyship. He brushed aside everything. And he goes on, my lord, to adjudicate. He should have adjudicated, my lord. First of all, my lord, a criminal court under the CRPC cannot review its own decision. His first observation upon receipt of the complaint was, my lord, on 6th of April 2023, peruse the application of Kuntal Ghosh, which he has placed through Correctional Home Authority. As regards his allegations against ED is concerned, I have nothing to say. And as regards allegations against CBI is concerned, I am at a loss as to why he has not ventilated his grievances at the very first instance. So he himself is surprised. Thereafter, there is completely a volte-face, my lord, and he assumes unto himself the role of, my lord, an extra constitutional, my lord, forum, I will say, my lord. That no, I have been given all the powers by the Honorable Supreme Court. Seems, my lord, I don't know, my lord. 226 also will be possibly adjudicated by him now. He will be issuing, my lord, writs of mandamus and habeas corpus also. So, my lord, this is one aspect, my lord. Now, what is to be looked into? But the Honorable Supreme Court says that whenever, my lord, in case of a complaint under section 191, subsection A, the mental process cannot remain conspicuously silent. Mind has to be exercised. The Supreme Court says that this is basically invasion on the privacy of someone, on the reputation of someone, unnecessarily harassing someone to go through the rigors of this procedure. But the Joint Commissioner, my lord, has made an observation about the role of the police. Thereafter, it is being referred to the police. From Caesars to Caesar's wife. When my lord is adjudicating, the court monitoring the investigation. My lord, as on date, since my lord is monitoring the investigation, my lord is the absolute authority before whom everything has to be indicated. My lord, popular muthaiya as I relied on, my lord. Now, my lord, so far as my lord 191A is concerned, first of all, my lord, he is not a magistrate. He is in the rank of an additional sessions judge, which again is a charge court, my lord. There are orders of transfer which has been issued. This particular court, my lord, there has been some other learned judicial officer, my lord, regarding whom, my lord, there has been a notification. There has been, my lord, the order has been passed, but it is not yet notified. And this is continuing unabashed, my lord. So, 2015, volume 12 Supreme Court cases, page 420. Now, the relevant paragraphs will be paragraphs 21 and 22. Well, last but one page, my lord, of the judgment. Para 21. Under section 191B CRPC, the magistrate has the advantage of a police report. And under 191C of the CRPC, he has the information or knowledge of commission of an offense. But under 191A, which is the case herein, though there was no complaint is with your ladyship, he has only a complaint before him. The court hence specifies that a complaint of facts which constitute such offense. Therefore, if the complaint on the face of it does not disclose the commission of any offense, the magistrate shall not take cognizance of cognizance under section 191A of the CRPC. Here, my lord, the discretion has been completely substituted. Inquiry has been directed whether to open the right window first or the left window first. Whether to, my lord, comb my hair, my lord, with my left hand or right hand. That is also been, my lord, directed, my lord, by, my lord, a learned judge in the court below who is not competent to do that, my lord. He cannot travel beyond the parameters, my lord, of the Code of Criminal Procedure. He is not having constitutional powers. He cannot pass orders at his own whims and caprice, my lord. And that too, my lord, the practice and precedent is, my lord, when there is a court which is basically a charge court, my lord, only, my lord, formal orders fixing next dates are passed. That is the system, my lord, which is prevalent, my lord. Here we find, my lord, I don't know, I will term it as extreme exuberance, my lord, to excel as, my lord, an adjudicator. And there was no power of adjudication, my lord. I reiterate, my lord, for the sake of prolixity also, my lord, I am reiterating the fact, my lord. No adjudicatory power, my lord, was conferred unto the particular, my lord, judge in the court below, my lord, but to adjudicate, my lord. It was just to raise the issue or take the point, my lord. That was what the Honorable Supreme Court, my lord, observed, and that was also confined, my lord, within the four corners of the order dated 18/5/2023, passed by your ladyship, which was not interfered with, my lord, insofar as the merits and the findings in the order is concerned, my lord. And my lord has thereafter, my lord, taken on record, taken note of the fact, my lord, of the reports which have been filed along with supporting evidence, my lord, which were deliberately not recorded. My specific case is, my lord, the learned judge in the court below has acted unwarranted, occasioning failure of justice, my lord. He has acted in a manner which is not warranted by law by not taking on record our submission, indicating that there has been subsequent orders passed, and deliberately ignoring the fact, my lord, as regards the findings of the Honorable Court monitoring the investigation, my lord, regarding the role of the police. And also, my lord, the order dated 13th of April 2023, which insulates the, my lord, members of the SIT who have undertaken the investigation. And also, my lord, I will say, my lord, this requires a formal admonition, my lord. He has, my lord, deliberately, my lord, he has deliberately, my lord, done something, my lord, which tends to impact, my lord, adversely, my lord, the dignity and majesty of justice, my lord, of a court of record, which we are, my lord, under Article 215. He has completely disowned and disobeyed the existence of the Honorable High Court at Calcutta. He has no authority to send anything directly to the Honorable Apex Court.
Very well. Now,
And my lord,
21st.
two more judgments, my lord. First is this, my lord, paragraph 21. Then, my lord, paragraph 22, my lord, the last few lines, my lord, that it has to be, my lord, this will be an abuse of process. And once, my lord, dignity will be unnecessarily affected, my lord. So, these observations, and thereafter, my lord, I'll be referring to Bhajan Lal's case, my lord. Bhajan Lal today. This is a case, my lord, with 1992 supplementary 1 Supreme Court cases, page 335. The exceptions have been laid down in Bhajan Lal's case, para 102. Para 102 will be at page 378, my lord, of my lord, the judgment. But I'll just place the paragraph, because this paragraph, my lord's query will also be answered, my lord. My lord, whether, my lord, in exercise of constitutional jurisdiction, my lord, it can be done or not. In the backdrop of interpretation of the various relevant provisions of code under chapter 14 and of the principles of law enunciated by this court in a series of decisions relating to the exercise of extraordinary power under Article 226, my lord kindly marks it, which my lord is exercising while monitoring this investigation, or the inherent powers under section 482 of the code, which we have extracted and reproduced above, we give the following categories of cases by way of illustration, wherein such power could be exercised either to prevent abuse of process of court or otherwise to secure the ends of justice. Though it may not be possible to lay down any precise, clearly defined and sufficiently channelized and inflexible guidelines or rigid formula, and to give an exhaustive list of myriad kinds of cases where such power should be exercised. My lord, straight away, my lord, comes to, my lord, the fifth and the seventh exception. The next page. Parameter 5, where the allegations made in the FIR or complaint are so absurd and inherently improbable, on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused. And thereafter, para 7, where a criminal proceeding is manifestly attended with mala fide, and or where the proceeding is maliciously instituted with an ulterior motive for wreaking vengeance on the accused and with a view to spite him due to private and personal grudge. So, my lord, the observations of the Supreme Court, the findings returned at by your ladyship, and also, my lord, the findings returned at by His Lordship, the Honorable Justice Gangobadhyay, my lord, in the order dated 13/4/2023, my lord, clearly can be clearly linked, my lord, with these two, my lord, parameters. And, my lord, I'll also link another, my lord, insofar as the factual aspect is concerned, my lord, as regards the delay, the inordinate delay, my lord, and an afterthought of Kuntal Ghosh, my lord, to do this, to derail the investigation. Our investigation as on date, my lord, is suffering for the past 3 weeks, my lord. We are all running after this, my lord. We are going to the Supreme Court once. We are coming before your ladyship. We are making applications before, my lord, the special judge to keep things in abeyance, my lord. My lord, kindly appreciate, my lord, the last judgment, my lord, that I will be citing. But this is reported in 2004 volume 8 Supreme Court cases, page 40. Here it was, my lord, more or less similar, my lord, factually. Paragraph 20. My paragraph 20 is last but 2 pages. When the background facts of the case are considered, the question regarding applicability of section 197 of the code takes a temporary backseat. The factual scenario as indicated above goes to show that on 28th of February 1991, the respondent was produced before the magistrate. He was specifically asked as to whether there was any ill treatment. Learned SDJM specifically records that no complaint of any ill treatment was made. This itself strikes at the credibility of the complaint. Additionally, the doctor who has examined him stated that for the first time on 2/3/1991, he treated the complainant. Though there are several other aspects highlighted in the version indicated in the complaint and the materials on record are there, we do not think it necessary to go into them because of the inherent improbabilities of the complainant's case and the patent malafide involved. It is no doubt true that at the threshold, interference by exercise of jurisdiction under section 482 of the code has to be in very rare cases. And this case appears to be of that nature. It fits in with category 7 of the broad categories indicated in state of Haryana versus Bhajanlal, which I just relied upon. It is to be noted that though plea regarding non-complaint before the magistrate was specifically stated to justify interference, the High Court has not dealt with this aspect at all, thereby adding to the vulnerability thereof. The continuance of the proceeding by way of prosecution in this case would amount to abuse of process of law. So, my lord, citing, my lord, these authorities, my lord, and the fact situation, as also, my lord, the findings returned at by your ladyship, my lord, which were not interfered with by the Honorable Supreme Court of India, my lord. I am submitting, my lord, before your ladyship in a court-monitored investigation. I am seeking, my lord, as of now, my lord, for quashing of this particular order, my lord, these orders, my lord, which are under challenge, my lord. And, my lord, the report, but there is another point, my lord, under the jail code, my lord. We have spelled that out, my lord, in our petition, my lord, that insofar as this prisoner's petition is concerned, my lord, this also is not in form with the jail code. But we'll find mention thereof, my lord. Kindly takes page 19, para 22 of the petition, my lord. Page 19, para 22. Yes, the 22. Applicants most respectfully submits that the purported complaints filed by the applicant Kuntal Ghosh dated 31/3 and 1/4 before the learned special court are honest in the eye of law, as the same is not in proper form and manner as provided under the West Bengal Jail Code, that the purported complaints made by the accused Kuntal Ghosh were made in prisoner's petition permitted under Rule 615 of the Jail Code. Rule 615 as provided under the Jail Code is for the convict's petition to the district magistrate or his erstwhile employer or official superior. If the form number has been indicated, we have annexed the relevant provision. It is submitted that said Rule 615 of Jail Code is only meant for convicts to make their prisoner's petition. The said Kuntal Ghosh has not been convicted so far in either in the predicate offense or of the CBI or the money laundering offense under PMLA. That Kuntal Ghosh is an under trial having U2P number such and such. An under trial prisoner is regularly produced before the concerned courts for extension of judicial custody period. I had indicated, the orders, of production. And it is a matter of record before the learned special judge CBI court at Alipur that accused Kuntal Ghosh was produced before the learned special court on 23/2/2023, 9/3/2023 and 23/3/2023 prior to his filing of such false and frivolous complaints against the officer of the applicant herein. The accused has never even made a whisper of any complaint before the learned special judge CBI court or on any dates, let alone making the false and unsubstantiated complaints of the custodial torture. Thereafter, apart from that, in the next paragraph, the superintendent of the correctional home has to hold weekly parade of prisoners as per Rule 646, Thereafter, Rule 1084 of the Jail Code, speaks about the complaint parades and 647 of the jail codes, my lord, at least, my lord, once in a day, visit all the prisoners and give them the opportunity of making the representations. My lord, this I will say, my lord, has already, my lord, fine, my lord, this has already, my lord, the hostility and, my lord, the nexus, my lord, with the under trial prisoner of the, my lord, the state administration has already been reflected in your ladyship's order, my lord, of 18th of May, which has not been, my lord, expunged or interfered with, my lord. So, my lord, I will be praying, my lord, for quashing of these orders, my lord, of the special court, my lord, and, my lord, I'll be pressing on, my lord, the prayer, my lord, that the report is before your ladyship, my lord. My lord, kindly, my lord, adjudicate, my lord, on the basis of the report which is before your ladyship, my lord.
Report you filed on the last occasion?
Yes, on 14/7, my lord. 14/6, we filed the interim report, and 14/7, my lord, we filed the final report, my lord. Both are with your ladyship, my lord. My lord, the difficulty is, my lord, the learned, my lord, judge, my lord, in the court below, he has made the case returnable again on 21st of September, my lord. So, my lord, may kindly quash it, my lord. Or, my lord, may kindly stay the order, my lord, if my lord feels, my lord, that affidavits are required, my lord.
You mentioned something in the morning.
What did I mention first, my lord, as far as this application is concerned?
Yes.
Though my learned counterpart has, my lord, I'll not make submissions, my lord, but what is happening, my lord, that in that particular complaint which was made, of which my lord is in season of, which was argued by us from ED, my lord, 2 of our officers have also been named. Now, special court has not given notice to CBI also, giving notice to us because we are in PMLA court. No complaint is before PMLA court. So we are not also privy to what is happening there, though our people have been unnecessarily arraigned in that matter. Now, my lord, before that, my lord, I have just made, because, my lord, I don't want to take much time of my lord. But, my lord, what had happened, my lord? Why my lord has jurisdiction? Just 5 minutes of my lord's session. My lord, just certain pointers, just a recapitulation as to why happened. Because this all was before my lord. And therefore, my lord wanted us to file reports. And reports have been filed before my lord. When reports are filed before my lord, and my lord is in season of the matter, my lord, this particular orders are unwarranted. Now, my lord will kindly see. And on what aspect, my lord? My lord, on 21st of January 2023, search and seizure was made at Kuntal Ghosh's residence. Then, my lord, on 21st, Kuntal Ghosh was arrested. Subsequently, there too, my lord, on 3/2/2023, learned special judge, special court KG, it was said, he was asked about his health. Nothing was. Then, my lord, what happened was, when second bail application was moved, nothing was complained by him that something happened during the police custody. Then, my lord, when third bail application was moved and it was rejected, nothing was said. That was on 17/2/2023, my lord. Now, on 3/3/23, fourth bail application was moved, which was rejected. Another application for medical treatment in the super specialty hospital was moved by him, which was rejected. Nothing was complained of. So, my lord, all these days when he was in the police custody with us, no complaint was made. Then subsequently, my lord, we had argued before my lord that being bolstered by a particular speech, he comes up, and my lord, now these matters were before my lord, and my lord was in season of the matter. My lord had asked report, we had filed that report. Now, my lord, we'll kindly see on 14/6/2023, my lord, first report was filed by CBI on Kuntal Ghosh's complaint. And, my lord, on 14/7/2023, CBI filed final report before this honorable court, closing investigation. So, my lord, everything is before my lord. Now, my lord, so this particular order, my lord, and, my lord, all applications can be filed before my lord. So, under these circumstances, my lord is in season of the matter, my lord. And what has happened, my lord, in this case? My lord will kindly take up. First of all, my lord, again, at the cost of repetition, my lord, the special court has no extraordinary power because, my lord, it has been established under the Prevention of Corruption Act, Section 3, my lord. And Section 5 gives the power to the special judge, which is only curtailed to the CRPC. Now, under CRPC, my lord, 482 is the only section which gives extraordinary power to this honorable court. So, my lord, when reports have been filed, my lord, the learned special court cannot order de novo investigation, that also by the authorities which have been kept in abeyance. My lord, now they are getting the state police into this particular investigation where it will be overlapping, and now it is retarding the investigation because we are being put to serious harassment. And we, ED, we are not also privy to any document from them. And now, my lord, before the PMLA court, my lord, this gentleman, Kuntal Ghosh, said that when the PMLA court asked him, my lord, I can give a compilation. It is all with my lord, because the last time when we argued, when my lord passed that order, which was challenged before the Honorable Supreme Court and not even touched, save and except, my lord, what has fallen. Now, my lord, there he said that nothing has happened. He was asked about his health. And about various, he said nothing. My lord will kindly recapitulate. Now, my lord, this is nothing but a ploy to harass us, my lord. And now, my lord, this judge in charge, my lord, exercising extraordinary jurisdiction from where he's getting power, my lord, we don't understand. And we are also not being allowed to, because, my lord, nothing has been sent. Our office has also named them, my lord. So, my lord, it is required, my lord, that my lord will kindly exercise power, my lord. Otherwise, my lord will kindly remember on the last occasion, my lord was wanting us to expedite. Now, how we will do this? At every nook and corner, every step, my lord, we are forced and retarded. The investigation is retarded by all these frivolous. My lord, we will fight them. We will run from pillar to post before this honorable court, or we will go on with the investigation, my lord. So, my lord, this particular issue has a checkered history where, my lord, he did not make any complaint regarding this. So, my lord, this needs to be, my lord, quashed, my lord. Well, we'll kindly see. My lord, I will give a compilation of dates, my lord, just a small list of dates, my lord. And, my lord, at the best, when 2 reports have been filed before my lord with regard to this particular investigation, at the best, my lord, the learned special judge could have said that they can ventilate their grievances before my lord because my lord is insistent of the matter. And because all applications, my lord, it has been directed by the Honorable Supreme Court that all applications are to be filed before my lord with regard to this. And, my lord, we'll see, my lord, another application which I was moving with, that will come before my lord. For trivial issues, my lord, where we have said before the coordinate bench of this honorable court that we are not going to use them, we have not seized them, we have given an undertaking. Then also, my lord, they are harassing us when there is an order.
But if only that application may be taken up on some other day. But I think
That application is not on record also.
My lord, my lord told me, my lord, we have filed it. I can give
Yes,
my
we
lord.
filed. We are not.
some other day.
My lord will either take, my lord will kindly take it up tomorrow, my lord. Because again, we are also suffering there also, my lord. This is one place where we are suffering because anything which is happening in this particular proceeding, my lord, our officers have also been named. That also at a later instance. Every day, the person is coming up with new names. Whoever is made in charge of the investigation, his name comes up. Therefore, my lord, in this condition, my lord, we are working for benefit of the public at large, my lord.
Would the state like to submit anything?
If your lordship kindly permits me,
Yes, certainly.
that I will be very brief. That this is an investigation of a public scam. The division bench of this court held this is a public scam. It should be investigated, and the constitutional court, in fact, has initiated the investigation on our prayer. And all the issues which are related to this investigation should come before this court. Now, the alleged letter of Mr. Kuntal Ghosh that was taken note of by this court, but apart from the fact that the contents are frivolous, anyone can read and start laughing, but I am not taking a lordship to that. And this court directed the CBI to investigate into the allegation. Now that investigation again is, my lord, initiated at the instance of a constitutional court. With deepest of respect, the court below shouldn't have at all ventured to interfere with that. If anybody has to say anything, ought to have come before a lordship. But the orders which have been placed by them, I am not repeating, in fact, really usurp the jurisdiction of the investigating agency by the court while the complainant says we have no grievance against the agency, then what is the intention? The intention is to delay the entire investigation, which has been repeatedly reprimanded by this court. That the public scam is again sought to be, my lord, hidden under the carpet, adopting these tactics. Therefore, my lord has the inherent power to stay these orders and direct the learned court below. So far these reports are concerned, that will be considered by this court as it is considered, the court is already in session of this matter. And the change of the investigating authorities for that purpose, with deepest respect, is uncalled for. I do not say anything more.
Well, the PP is here. His application.
I just came to know, my lord, from certain that an ED has filed an application.
That application is not on record.
My lord, that application, my lord.
It's not on record as yet.
So, my lord,
We are not hearing that at least.
so let a copy be served upon my office. I will
Certainly.
definitely
Certainly it will be
address
served.
before your lordships, my lord, on that point. Because only one thing I am pointing out before your lordship very kindly. Just a minute, Mr. Dhiraj Trivedi, and let me submit, sir. 1 minute. Let me submit.
Sorry.
My lord, Mr. Bikash Ranjan Bhattacharya, learned senior advocate, and Mr. Dhiraj Trivedi was not there, my lord. But everybody had appeared before Justice Tirthankar Ghosh. And Justice Tirthankar Ghosh with regard to those 60. No, you were not there. Sheta noy. 16 downloaded files, my lord. Justice Ghosh made us a party there. And then, my lord, we had handed over the hard disks to the CFSL pursuant to the orders of Justice Ghosh. Justice Ghosh directed downloading of those files. Thereafter, Justice Ghosh again directed that those be submitted to us. That means the cybercrime cell. So, my lord, whatever before your lordship, since the application is not there, your lordship will fix a date. I'll come up before your lordship.
Let the application appear in the list. We
As
will
well, Lord.
certainly fix up a date.
Yes, ma'am.
Tomorrow, my lord, so didn't fit and properly.
My lord, what?
Not tomorrow. Come on Monday in that case.
Yes, my lord, come on Monday. I will address it.
Tomorrow it's not possible.
My lord, they should not harass us by writing letters and.
My lord, just before Justice Ghosh, the same point was agitated that they have written mails and they have Justice Ghosh orally said that yes, if you have written mails, you reply or you don't reply. That is up to your wish. But that doesn't mean that they will raise this plea now again here, because once they have agitated the same point before Justice Ghosh.
Sir,
Where will the
that issue is
application,
being
let the
adjudicated
application
by the
appear?
Yes, sir is there. Same thing, my lord, same issues are before Justice Ghosh.
the only
Monday, let it appear. We will see what is to be done. And when is the matter? When will the matter be taken up by Justice Ghosh?
My lord, Justice Ghosh has reserved it, saying that they have given final list of judgments and written arguments. So matter is fixed on 19th. They could have moved this.
19th.
Yes, they could have moved this application before Justice Ghosh because he's arising out of the self-same issues.
Lord, we will address, my lord, why we did not. My lord will kindly see, is the application.
No, we are not hearing that.
Well, there cannot be
Yes.
conflicting approaches before the different courts. In just
Well,
court
we will
34,
start
they are
up,
saying something.
I will
In
not
court
cut
here,
off altogether why I am approaching my lord.
No. Listen,
No,
let us come. Let us meet with the application
Yes, my
on
lord, that is what I'm saying, my lord.
on
I'm not forwarding my argument. I'm just retaliating to what is.
on the 20th, because 19th it has been fixed by Justice.
well, can it be on 21st, subject to your lordships? The 20th.
Then,
My lord is fixing on 20th.
no, thing is that the ED officials are apprehending some type of action from
Well,
your
it's
end.
only
They
at the
are-
stage of GD, general diary.
Whatever,
Of this.
whatever.
Whatever,
they
my
will-
lord keeps it. My lord, my learned friend will be prejudiced. He is there, my lord. See, if
No,
you ca-
he will always be here.
no, my lord.
You may not be here, but then he will
I
be.
have some personal difficulty. I cannot
20th.
able to express my,
So kindly keeps it on 23rd. Nothing more.
20?
21st.
21st.
21st. All right. October.
no.
21st is
September. September.
ও সবসময় এগিয়ে থাকে
Next Thursday. Next Thursday.
next Thursday.
And in the meantime, let these officers not be harassed.
Well, we have never harassed. We have writing
say-
mails is not a harassment. They can appear. They choose not to appear. They choose not to reply.
No, then that gives a wrong message also.
Well, that
So that has to be kept in mind. You are writing mails
yes.
and then not replying or returning to the mail will
Well,
give
they
a wrong
can say well,
indication.
they have already replied first time. They have said
Then don't send any further
Well, we
mail.
have sent it, my lord, they will not reply.
No, why will you send? Tell me one thing. If you have sent a mail and there is a reply, what is the requirement?
They
of
replied,
submitting?
said they never stated anything in their mails. That is why we said raise further questions.
Since it is before
All
the
right, my lord,
honorable
we'll keep,
judge,
I will,
it is better
as your lordship,
do
21st.
not send any further mails. Whatever the honorable judge will do, let us see.
Let us
Then
see.
thereafter,
Yeah, exactly. my lord.
everybody can
Everybody,
pursue their own remedies.
exactly, my lord.
Only with the approval of my submission kindly goes to the order of 13th April 2023, where the court directed it should be investigated by the CBI itself. That is at page 33 of the application. That's all. Chalo.
My lord, with regard to my lord, the CBI's application, CBI's application, my lord, I don't have much to say apart from the point of view it has already fallen from your lordship, because what they say is what I've gathered, but is that their submissions are, my lord, are on the periphery of abuse of the process of the court and the securing the ends of justice. So that, my lord, that remedy they have under 482. But what I'm trying to point out, and my lord will kindly not take me amiss because I was getting the submission, that whatever is transpiring before the learned magistrate is at the instance
Not the magistrate. He's not the magistrate.
my lord, before the, my lord, the
Special judge
special CBI
in charge.
at the instance of someone. Now, my lord, that person is not before your lordship, my lord. Who is defending this application, I do not know. He has moved, CBI has moved it, but who is defending it, I do not know. But, my lord, that perhaps maybe the reason they are not before a 227 court, where they had to make the person a party. Because the parties are before your lordship in other
No, no, in
applications.
27 proceedings also, there is no question of service, my lord. When, my lord, the initial
At the
stage,
instance, at the first instance, I understand. But here, there is no one to defend the application.
my
So
lord,
they filed applications for intervention, but that was rejected.
this is by your-
That was rejected.
Let me reject it, yes.
Yes.
In the midst of all this, the real issue is going out of concern. Kindly take some my lord's order 29th August 2023.
Certain reports were directed to be filed.
Yes. The reports are not coming.
No, I have a report. I also have a report.
Yes, let it be placed. Let,
Against all odds, we are still investigating
Therefore-
and we are progressing.
how do you know?
Kindly take the report, my lord. My lord, the
Yes.
report
Let
will be
the,
spelled out.
Yes, please.
My lord.
DD is also filing.
My lord, kindly, my lord, I'll get a copy fix করলো, ধীরে কবে fix করলো?
21st. Next
Next Thursday, my lord, the report we are filing, my lord. My lord, kindly, my lord, place the order, my lord, for the order, my lord, of the special judge, my lord. Reports, my lord, may it be kept on record. My lord, to kindly take, consider the report, my lord, on that day.
Let me see what.
the report by the board is not filed, which is more important.
Only one thing, my lord, that I will like to indicate. I had indicated it before the Honorable Justice Gangobadhyay also in the pending application, my lord. But we are filing the reports, my lord. I'll urge your ladyship, my lord, not to, my lord, even, my lord, disclose, my lord, what is there in the report. We have made that particular prayer also, my lord, in the last portion of the report. But now, my lord, they are getting to know the line of investigation undertaken by us. But as I was referring to, there now twin towers. This is doing rounds, my lord. This has become viral. SSC and primary, my lord, they are two towers of corruption. Now in SSC scam, my lord.
No, but the municipality is also rising its head.
Yes. Municipality, I'm thinking, my lord, how to term it, my lord. Trump Tower, no, Burj Al Arab.
Let us come to the issue. But the report by the board is necessary.
Now, my lord, what has happened is, my lord,
Why
the
not doing that?
scam. We had indicated, my lord, what we had retrieved, how we had recovered the OMRs. Now they got to know our line of investigation. Now in respect of primary,
Yes.
what they have done is this S. Basurai and company, who was entrusted with the duty of preparing the OMRs, tabulating the marks and all. What they have done is retreat, my lord. They say that no, we do not follow the system of keeping any OMR sheet, soft copy of OMR sheet.
আগেকার দিনে যে রিপোর্টটা
We
ছিল
do not have any scanned images.
ED, get that envelope.
No, but why is the report by the board? That was
Was
the
the board also
specification.
supposed to file? What are, have you taken any steps? Please come up, what you have done.
The board shall verify the credentials of the candidates, and if it appears that any of the candidates in the said list was appointed derogates of the provisions of law, the prompt necessary steps shall be taken. That was the steps to be taken.
What steps have you taken?
Yes, we have forward, we indicated that in the report.
What steps have you taken? You have annexed a big document. What are these? Now, to Kaushik Chaudhary, advocate, pertaining to the steps taken as to the board in respect. What are the steps taken? You have called them for hearing on the 19th.
By 4th of October, my lord, we
By 4th of October. Let the report. আমাদের কপি দাও কি করছো ফাইনাল রিপোর্ট 4th of October.
This is only showing that the names have been forwarded to you. The list containing the names on verification. Yes, ED has submitted pages containing 1894 selected candidates. On verification, we found that selection were made strictly as per the methodologies adhering to the 2016 recruitment rules. And the second list contains 250 candidates relating to such and such. The verified names out of it found authentic. Out of 250, you found 248 to be authentic. And this, you do not have? Two, you do not have any existence in your record. How do they get appointment? If you do not have any existence, you have not recommended. Check up whether they are serving any school or not.
I have already
And 63 candidates, their names have been verified. You have finished verification. Then why did you?
The report are
Yes.
we have verified from our report and my lord, later.
And you found everything is all right. The documents and everything is all right.
Documents, they all are in our.
And what about the OMR sheets, the marks granted to them?
no, in all cases. No,
You
they have to produce your OMR sheet to show.
take this back because this will not be
Line of
required.
Investigation of the SSC scam. Now they are doing the needful in so far as the OMRs are concerned.
Please come.
Now.